Ladies and gentlemen, this is Olayemi Dear Corolla Daniels, popularly known as Dear Court Spectre, and welcome to another episode of Dear Court Talks Law. So guys, today we are talking about public nuisance. Yes, we are talking about public nuisance, and I've already made a video on the introduction to nuisance. It's going to be showing on the screen right now, where I discussed about different things regarding nuisance. However, I was talking about the surface area of nuisance. Now, I told you in that video that I'm going to make another video entirely on public nuisance and another on private nuisance. Now, this is the one on public nuisance. Private nuisance is going to come subsequently. So if this is your first time of visiting my channel, I want to say a very big welcome. So make sure that you click the subscribe button and also click the notification bell, so that anytime I release a video which could be of interest to you, you are going to be one of the first set of people to watch that particular video. And also make sure that you give this video a thumbs up. Thank you very much. So moving into what we have today, we are talking about public nuisance. Now, when we talk about public nuisance, the definition in relation to public nuisance, there are three things that you must note in relation to public nuisance. Now, public nuisance is any conduct that interferes with the reasonable conduct or convenience of the public. Do you understand? Three things. The first one is that there must be a conduct perpetrated by a person or a group of people which is, detrimental or which interferes with the reasonable comforts or convenience of, number three, the public. Those are the three things that must always be in your definition, or three things that you must always take note of when you are talking about public nuisance. Now, moving on, I'll be talking about two things especially: who can sue for public nuisance and what are the elements of public nuisance. So who can sue for public nuisance is going to come before what the element of public nuisance are. The reason is because who comes before the court seeking a relief for public nuisance matters a lot in determining what are the elements that the person is going to prove. So there are three sets of people that can sue for public nuisance: either the AG of the state or the federation, or the police, or an independent person. So there are three sets of people that can sue. Now let us start with the AG. Now the AG is the Attorney General. That's like either the Commissioner for a state, as Commissioner for Justice in the state, or the Minister for Justice in the Federation. So it's like the number one person when it comes to the ministry in that particular state or the Federation. So as regards public nuisance, the first person that you set your eyes on is the AG. That's the first person that can sue in an issue for public nuisance. And that was held in the case of AG versus PYA Quarriees, and also the case of AG versus GASTONIA Coaches Limited. Now, in the case of AG versus PYA Quarriees, do you know what a quarry is now? When you destroy rocks and stone. So when you are hitting rock and stone and all that, the thing is going to be flying out. So the thing was flying out from the factory or something, and then it was disturbing neighboring villages and all that. Now, the defendant in that case, that's PYA Quarrie's, was arguing before the court that this is nothing but a private nuisance, and therefore, we need not have an AG self here. Do you understand? They were trying to challenge the validity of the standing of the AG, but the court held that it was a public nuisance, and the first person that you run to in relation to a public nuisance, whether or not it's a crime or a tort, is the AG. Do you understand? And that is the same thing you would have in the case of AG versus Gastonia coaches, where there was noise and all that. Now, the court still held in that case that yes, the AG was entitled to relief. And the relief that the AG was seeking for in that case was an injunction to stop Gastonia coaches from making such noise, disturbing the public. Do you understand? So the first person that you run to in a case of public nuisance is the AG, and I've given two cases, AG versus PYA Quarrie's and also AG versus Gastonia coaches. Now let us move to the second person that can sue, and that is the police. Now when it comes to minor torts and all that, like public nuisance, the police can also sue. I don't think there is any case recorded in Nigeria where the police sued for public nuisance and all that. But now let's go to the third one, which is an individual person. Yes, an individual person can sue for public nuisance. However, there is a condition to that suit, and that condition will be seen when we are talking about the elements of public nuisance. So now, when you are saying that the AG is to stand before the court and sue a party for public nuisance, what are the things that the AG must prove before the court? Now, as well as the police, what are the things that the police must prove before the court? And also, the individual person, what are the things that the individual person must prove before the court? The first thing that they must prove is that this particular act done by the other party must have affected a class of people. That particular act done by the other party must have affected a class of people, not just one person, but a class of people. Now, if you look at the case of AG versus PYA Quarrie's, the court held that any conduct, for it to suffice as public nuisance, it must be such that it will be unreasonable for one person, or for us to expect that one person should bring an action. Do you understand? When a particular conduct affects more than one person, then it is a public nuisance. Do you understand? When we are talking about class of people, according to Roma J, he said that it is a question of fact whether a sufficient number of people have been affected to amount to a public nuisance. We have to check the fact of each case to determine whether a sufficient amount of people have been affected for that to be regarded as public nuisance. Do you understand? So when we are talking about sufficient amount of people, or when we are talking about class of people, or when we are talking about public, what do we mean? Now imagine that you are about to leave your house, or let's say you guys live in a particular estate. Now something happened to the gate of the estate, and then the gate was blocked. Nobody from the estate can move out. Can we say that that is sufficient to be a class of people to have been affected by that act? Yes, because according to the case of AG versus PYA Quarrie's, where that conduct is such that it will be unreasonable for us to say that it has affected just one person, that conduct therefore amounts to a public nuisance. So in that case, you can see that when the gate was blocked, the whole people in the estate could not move out, others could not move in, and therefore it affected at least a sufficient amount of those living in that particular estate. So what you will regard as a class of people will vary from place to place and from fact to fact. Do you understand? So you have to look at the fact of every case before you decide on what class of people is. You have other class of people like people with common characteristics or local community or things like that. When you're talking about a class of people, we have to look at the fact, and we have to look at, is this conduct such that they have affected more than one person? Yes, if that conduct has affected more than one person, then it has met the first criteria of the first element of nuisance in this case, which is class of persons. Number one. Do you understand? Number two, the act must be material. That conduct which we are claiming is public nuisance must be material, and it must have caused serious inconvenience to the public, which is very, very important. And then the third one is that the claimant must have suffered special damages. Those are the three elements of public nuisance. The first one, like I said earlier, is that it must have affected a class of people. The second one is that particular act must be so material that it will have caused serious inconvenience to the public. And the third one is that the claimant must have suffered special damage. Now, note that when the AG and the police is going before the court to allege nuisance, all they need to prove is the first and the second one. The third one is only needed when a private person or people coming in representative capacity is trying to abate a public nuisance. Do you understand? Now, let me give particular cases in relation to that. The first case I'll be giving is the case of ADENIRAN versus INTERLAND transport. Now, in the case of ADENIRAN versus INTERLAND transport usually had trailers and all that, and those trailers used to park where, you know, ADENIRAN and the rest usually have their place of worship and their residential homes. Now, ADENIRAN argued before the court that the trailer that INTERLAND transport has used to cause a lot of noise as well as dust and vibration, and it makes the place uninhabitable for them. Do you understand that? Now, the INTERLAND transport argued before the court that they do not have local standi to come before the court because it is only the AG or the police that is supposed to sue. Now, the court held in that particular case that because of section 6 subsection 6b of the 1999 constitution, every single person has the right to go to court when he feels that he has been wronged or his rights is being breached or has been breached. Do you understand? So by virtue of that section of the constitution, then ADENIRAN can go to court to seek a relief or a declaration. Do you understand that? But the court also added that for the suit to be complete, then ADENIRAN must prove that he has suffered damages far and above every other party in the public. Same goes to the case of Amos versus Shell BP. Now, in that particular case, there was this particular waterway, just like a creek, which Shell BP obstructed, and this made water to be going into people's farmlands and destroying their crops and all that. Now, Amos, along with other farmers, came up to sue Shell BP in their representative capacity, that's in their representative capacity of the community. Now, the court held in that case that yes, they can sue on behalf of the community. However, those people that are coming to sue, so if we are saying that there are 10 people joined to that particular suit, those 10 people must prove individually their damages. They must prove individually special damages that that particular act of Shell BP has caused to them. Do you understand? When we are talking about public nuisance, we are looking at three elements. That act must have affected a class of people. That act must be material. I have not given case on the materiality of the act, but I have given you cases on the fact that each of the claimants must prove special damages, and that is the case of ADENIRAN versus INTERLAND and Amos versus Shell BP, where the court held in both cases that individuals can bring action for public nuisance, but they must prove special damages. They must prove how the conduct of that particular person has affected them far and above every other person, and also they must also prove that that act is material. That is the case of Rose versus Miles. Rose versus Miles, where the waterway was blocked, and then the plaintiff who was carrying load on his boat had to take the load down and had to spend extra costs, do you understand, to transport the load to its destination. That cost which you wouldn't have spent if you was using the waterway. And you know that that particular obstruction on the waterway affected the public, but the claimant had to show that he had suffered more damages than the public. Not everybody is going to be taking their load through the water. Do you understand? But in this case, the claimant was taking his load through the water, and then he had to show the court that he himself has suffered special damages far and above every other person in the community. Do you understand? So we have other cases like Campbell versus Paddington Compression. We have the case of HASLEY versus ESSO Petroleum. We have the case of Savage versus AKINRINDE. We have the case of TARCY versus ASHTON. We have the case of Benjamin versus STORR. We have the case of Vanderpant versus MAYFAIR Hotel. You see, in all these cases that all have numerous facts, you are going to see one thing similar in every of the cases. The court will hold that that particular act or conduct must have affected a class of people. That is number one. Number two is that the conduct which is causing the inconvenience must be material. And then number three, if a private person wants to claim, for a public nuisance, then he must prove special damages. Those are the three things that must be in every suit relating to public nuisance. Do you understand? Now, the video is going to be showing on the screen again where Techno carried girls to Third Milan Bridge. According to him, he said he was transporting them to a particular location where they are supposed to make videos and all that and all that. I told you earlier that public nuisance could be a crime and then could be a thought. Now, we are not looking at the element of public nuisance in relation to crime. We are looking at the element of public nuisance in thoughts. Now, let us start with class of people. Can we say that that act has affected a class of people? Yes or no? Now, we can actually say it has affected the class of people, because if you look at people that could be on Third Milan Bridge on that particular day, they could have been Christians, they could have been pastors, Muslims that are really religious, and it would be unfair to them to be open to those kind of things. It's not everybody that is comfortable with things like that. Do you understand that? That is number one. So yes, let's say yes, it has affected the class of people. We are assuming that those people are there. All those things have to be proved before the court. So you have to bring at least two people who can testify to being there and who can testify to the fact that it has affected them. The second thing is the conduct now in itself. Can we say that it has caused serious inconvenience? Now that now depends on the judge and on the person that is arguing, the person that is going to present that case, because it depends on how serious you paint the case to be. Some people can say that that particular conduct is a very despicable conduct and not something that people should be prone to, especially when they have their children in the cars. Do you understand? If your children are in the cars, I don't think that any parent will want their children to be exposed to things like that, because it starts building up in their subconscious, and all of a sudden they might want to start liking it or exhibiting such acts. Now that argument, if tailored and presented very well before the court, can make the court think, or at least see that yes, there is actually a serious conduct here, that there is a serious inconvenience here. Do you understand what I'm saying? Now, the third one is that claimant must now prove special damages. This is where it might be difficult for individual parties to bring an action in relation to that particular act. So only the AG or the police can bring an action without having to prove special damages. Now, what kind of special damage will someone who is driving back from work say that this particular act would have cost him? I don't know, except you are a very, very smart lawyer or something to be able to bring special damages that you would have suffered far and above every other person from that particular case. I think that it is very, very difficult for a private person to sue. I am not saying that it is impossible. I'm saying that it is difficult for a private person to sue in relation to this act. However, it might be much, much easier for the AG or the police to sue. So now, rounding up my lecture today, I want you to know two things. And out of those two things, you need to know three things. When you are talking about public nuisance, that's the first thing. Three things must be in your definition. There must be a conduct which must have caused inconvenience to public. That's number one. Then the number two are the elements of public nuisance. There must be a class of people, there must be seriousness of that particular conduct, and then number three, the claimant must have suffered special damages. So with that, I call it a day, and I say thank you so much for watching this particular video. Make sure that you click the subscribe button and also click the notification bell, so that anytime I release a video, you are going to be one of the first set of people to watch that particular video. Thank you very much for watching. My next video is going to be on private nuisance. My name is Olayeni, dear Kolola Daniels.